Welcome to Dementia-Friendly Prince George's County, Maryland, Northern Sector webinar series for caregivers. Today's topic is Advanced Directives in Maryland, sponsored by Prince George's County government and the Department of Family Services.
Hi, I'm Darlene Powell. I'm one of the staff attorneys at Community Legal Services of Prince George's County. Today I'm going to talk about advanced directives in Maryland. In Maryland, we have what's called the Maryland Healthcare Decisions Act. That provision of the law allows you to create an advanced directive. What is an advanced directive? Essentially, an advanced directive is a document or series of documents that you complete so that someone knows who has authority to make decisions on your behalf when you're unable to do so in a medical context. What are the types of advanced directives in Maryland? The most common types of advanced directives in Maryland are the healthcare power of attorney and a living will, although there are other types of advanced directives such as a do not resuscitate order and so forth. Why should you have an advanced directive in place? If you're unable to make a healthcare decision, it would be better to have someone whom you've selected in advance to make that decision for you than to have a doctor or a hospital try to guess who has authority to make the decision, or a hospital or medical provider may think that you want your spouse to make the decision, whereas really you wanted your sister to make the decision. So having an advanced directive in place makes your wishes perfectly clear. The healthcare power of attorney in Maryland. What is a healthcare power of attorney? It is a document wherein you designate an agent to make medical decisions on your behalf. Your agent typically could make any medical decision that you would be able to make if you were able to make it. For example, if you are unconscious and therefore unable to make a decision, your agent under the healthcare power of attorney could make that decision on your behalf. When does a healthcare power of attorney become effective? Generally, it becomes effective when you're incapacitated in some fashion and are unable to make a medical decision on your own behalf. Healthcare agent, the person who makes decisions for you under the healthcare power of attorney, is your healthcare agent. What factors are important in selecting a healthcare agent? It's important to select someone whom you trust, someone whom you know well, and someone who is going to carry out your wishes as far as it pertains to medical matters. You want someone who would be able to exercise good judgment and someone who's always going to be looking out for your best interest. Why is it important to name an alternate agent? The agent you name may be unavailable for some reason. For example, your agent may be out of the country, or the hospital or medical provider can't reach your agent. In that case, the alternate agent would be able to step in and make those important medical decisions for you. Why is the residence of your agent important? The residence of your agent could become important. For example, if you live in Maryland and your agent is in California, it may be difficult for them to get enough real-time information in order to make important decisions on your behalf. For example, if your agent is local, typically they'll be able to go to the hospital, speak with the medical provider in detail, be fully advised of the pros and cons of an expected course of treatment, and so forth, whereas an agent in California may just get a 3-minute telephone call and bits and pieces of information, and then they're supposed to make a decision on your behalf. So it's something to really keep in mind. If possible, it's probably a good idea to have someone who is likely to be available in the event that they have to act. Co-agents. Some people want to name 2 agents. For example, they may say, well, I have 2 children and I want both children to be able to act equally. In terms of pros, that's good. You're keeping both of your children in that scenario involved. However, what happens when your co-agents can't agree? When your co-agents can't agree and there's a deadlock, you may not be able to get certain treatment because the medical providers are afraid to move forward without getting some sort of court order, since the co-agents would have equal authority. I typically don't recommend co-agents. I recommend an agent and an alternate agent. If you have multiple people whom you want to be involved, you can add additional language to your healthcare power of attorney indicating that your agent needs to consult with certain other people and so forth before a final decision is made. The authority of the healthcare agent, essentially the types of decisions that your agent can make is any decision that you could make in the medical context if you were able to do so. What if you want to make a healthcare decision rather than have your agent make a decision? If you're able to make the decision, then you make the decision. If you're temporarily unable to make a decision, then your healthcare agent would step in. As soon as you're able to make a decision on your own, then you make the decision. A living will is another type of advance directive. What is a living will? Essentially, a living will is a document that sets forth your wishes. If you're in a situation where you're in a coma or a vegetative state or other state where you're unable to communicate, not likely to recover, and so forth, and don't want to be kept artificially alive on a machine. When does a living will become effective? Typically, a living will is drafted to become effective when two physicians indicate that there's no hope of recovery and that you're not going to come out of that comatose state or vegetative state or similar situation. What language can be added to a living will to provide comfort? You can add language to a living will that may say, although I don't want to be kept artificially alive on a machine, I do want hydration, a feeding tube, or pain medication to provide comfort. What happens if you do not have a living will? If you don't have a living will, but you have a healthcare power of attorney, then your agent would make the decision whether or not to continue life support. However, your agent then has the burden of deciding what it is that they think you would want in that particular situation. If you clearly don't want to be kept alive artificially on a machine in certain situations, then you should probably create a living will. That way your agent or other family members, if you don't have a healthcare power of attorney, don't have to have the burden of trying to decide essentially in a life or death situation as to what it is that you likely would have wanted. Additional considerations, some people do a healthcare power of attorney only. They don't want to decide now whether or not they want to be kept on life support, in some future situation. So they only do a healthcare power of attorney, and that's fine. And as I may have mentioned earlier, your agent under the healthcare power of attorney, they can make that decision whether or not to continue life support. You can do a living will only. You may not want to designate a healthcare agent, and you may only want to do a living will. And you can, and that's perfectly fine. And a lot of people do both a healthcare power of attorney and a living will and have both documents in place. What happens if you don't have either document in place? If there's no one designated to make medical decisions under the Annotated Code of Maryland, there's a certain priority as to who can make certain medical decisions. Alternatively, your family members or loved ones may find themselves in a situation where someone needs to petition the court to become your guardian. That can be a long and lengthy and expensive process. So it's better to have at least a healthcare power of attorney in place, so there's a designation as to who should act on your behalf. Witness requirements for advance directives in Maryland. There are very specific witness requirements, including your witnesses must be adults over the age of 18 years. Your healthcare agent or any alternate agents cannot be a witness to your advance directive. At least one of the witnesses must not knowingly be entitled to any portion of your estate, and they also must not knowingly be entitled to any financial benefit by reason of your death. Electronic signatures, as we evolve in this computer age and electronic signatures become more popular, there are situations where you can sign your advance directives electronically. In those situations, witnesses might not be required, but there are very specific requirements in that situation. So in order to ensure validity of the documents, if you're going to sign them electronically, then you need to discuss with a lawyer what those specific requirements are at the point in time where you're ready to sign. As you know, there are revisions to Maryland law on a regular basis. So for something like electronic signatures, you definitely want to check right before you sign those documents to make sure it's in accordance with the then current Maryland law. Where should you keep your advance directive? The original should be kept in a safe place, easily accessible to your agent. Additionally, copies should be placed in the medical files. If you're having surgery or admitted to a hospital, you should have copies of those placed in the hospital files as well. If you have any other questions about advance directives in Maryland, please feel free to contact Community Legal Services of Prince George's County at the telephone number or the website address listed below. Thank you. This presentation is part of Dementia Friendly America's initiative, specifically Dementia Friendly America, Prince George's County, Northern Sector. You can learn a lot more about Dementia Friendly America and all the different communities involved in this movement online. Dementia Friendly America, Prince George's County, Northern Sector has virtual support groups. Please consider connecting with one of these groups. Also, there are monthly email newsletters to keep you informed and provide important information. There's also an upcoming webinar series. Dementia Friendly America Northern Prince George's County has a YouTube channel now, and you can view educational videos on a wide range of topics. For additional information, you can contact Sharon Johnson at the phone number or the email address listed on this slide. Thank you.